Yeah. Yeah.
Big one.
Go big or go home.
Yeah, exactly. I know when to switch.
That's what I said. From now on, every time we come in here, it's going to be a payoff, too. Who's always been a pro?
Yeah, it's been great.
Well, I'll just accept that this is a case of extreme circumstance. Next time, I'll be like this.
Court is back in session, please remain seated.
All right. The court is in possession of the defendant's written motion for judgment of acquittal that was filed on November 18th. Mr. Matthews, anything further on that issue?
Judge, I would just like to reiterate, number one, with reference to the voluntary manslaughter count, there was absolutely no evidence in the record regarding a sudden fit of rage or sudden passion. And for that reason, I would submit that charge should be dismissed outright. With reference to the murder count, I have it on very good authority from three sources that the vote at the time of this trial was declared was 10-2 for not guilty. And I would argue to the court that deference should be given to that majority vote of the jury, that count should also be dismissed. I would submit that further.
Very good. Anything from the state?
Nothing other than the arguments with Bruce and Edwards.
Very good. Viewing the evidence in the light most favorable to the state of Ohio, which is the required legal standard, the Rule 29C motion is overruled. The court has another issue to place of record on this matter. First and foremost, let me say that despite all the superfluous noise involved, I could not be more impressed with the defense team, the defendant and his family, and his supporters, and how they conducted themselves throughout the trial. Likewise, the state of Ohio was represented by three of the best lawyers in this county. The family members and supporters of the DuBose family were wonderful and conducted themselves exactly as they should. The folks who came down to the courthouse and watched in adjacent rooms stood outside and carried on their peaceful and meaningful protests. I am glad and pleased and impressed with the fact that we are hopefully setting a new standard on how these cases will be handled. It's unfortunate for everybody involved that a decision was not reached. Everybody wanted a decision reached in this case, but it is as much a part of our system as is a decision, and that is when a jury cannot reach a verdict, that they indicate as much to the court this jury tried harder than anybody could have expected. I think that both the state and the defense would have to agree to that, despite the outcome not being favorable for anyone. As the parties know, the court has made dozens of rulings on the evidence and the procedures in this case. Some of the rulings favored the state of Ohio and other rulings favored the defense. Many of the rulings favored neither side, but advanced the court's particular view on how the case should proceed. The state's announced that it will retry the case, correct? Very good. It's this court's opinion that the retrial should be conducted with a blank slate on all matters surrounding evidence and procedure. Thus, under Revised Code 2701.03a in the Judicial Canon 2.11a, I find that this court is otherwise disqualified to preside over the retrial of the State versus Raymond Tenzing. Upon the selection of a new judge, all future motions and matters surrounding State versus Tenzing shall be presented to and disposed of by that new judge. Prior to me initiating the entry recusing on this case, are there any outstanding motions as far as the state is concerned that need to be addressed?
No, Your Honor.
Are there any outstanding motions as far as the defense is concerned?
No, Your Honor.
Very good. Mr. Dressing, thought I saw him in the courtroom. Very good. I will briefly adjourn to receive I've ordered the roll for the new judge, the judge that will be presiding over the retrial of this case, and I will include that in my order and announce it here in open court as soon as we receive it.